Okay. So today I'm going to talk about AI-driven manipulation, not about we are manipulating AI, but more about we are being manipulated by AI. And I tentatively call it cognitive threats because I realized that manipulation has a long history in philosophy and regulation and many other disciplines. And sometimes some scholars think that manipulation in a very strict way. And so I'm currently looking at more threats or harms focus versus manipulation. So my thoughts are really evolving now. And so it's really half-baked proposal. But yeah, I'm very excited to hear your thoughts about this topic. And second, I will mention that it's frustratingly difficult to regulate AI's cognitive threats or AI's manipulative potential, and partially because of the First Amendment. And I'm going to talk about only First Amendment part today, not other parts. But still, First Amendment is really worth a lot of discussions. And then I'm going to talk about a little um, paradoxical naming of human-centered First Amendment, because First Amendment should be very human-centered, probably the most human-centered principle in the U.S. Constitution, but it has not been that way. It has been surprisingly corporate friendly. So there are multiple reasons for that, and so I'm going to talk later more about it. And so this research about AI-driven manipulation starts from my interdisciplinary workshops with my colleagues in January 2023, when ChatGPT just came out, and I was freaking out and everybody else is freaking out, and there were some excitements and some concerns about it. And so we did little experiments of like putting the post-its and on the wall with computer scientists and some psychologists, and then I figured out some concerning scenarios regarding it, including educational inequality if some rich communities get great access to fascinating models, but poor school district might not have that. And propagation of bias that is very well known to everyone in this room, and polarization. And so if AI could reinforces any types of polarization that is already existing in social media, and it could be really concerning. Each community would fine-tune their own models, and then they're going to be just in more and more echo chambers. And emotional over-reliance part was very interesting to me. And it's really happening now because there is some services like giving creating your former partner replica using LLMs. And so there is going to be some great use cases like allowing you to talk to your deceased parents or deceased siblings, and but it still touches on your emotional and psychological like elements of you, and then it could create over reliance in a very remarkable way compared to maybe Tamagotchi or Pokemon Go, and it's going to be really concerning and deep. And the other thing is that if that kind of emotional reliance could merge with virtual reality tools, and then maybe there could be some sexual abuse or other types of violence in the virtual reality. And so those are like five the most interesting scenarios that we could come up with. And I was surprised by that most of these things might be poorly addressed through the existing legal tools, because existing legal tools mainly focus on intentional harms and tangible harms, but these scenarios are mostly unintended. There is no clear person or entity that holds like full accountability or liability for these outcomes, as well as the harms are mainly psychological and intangible. So there is no clear like physical damage or financial costs. And in that way, the existing liability-based legal framework may not really work well to address these threats. So this is the quote that Peter liked and somebody didn't. Some of them don't really like in my lab. And so I really like this quote coming from 1960. Complete subservience and complete intelligence do not really go together. If the machines become more and more efficient and operate at a higher and higher psychological level, the catastrophe of the dominance of the machine comes nearer and nearer. So it's going to be sophisticated and smarter, and so that they can replace some of our tedious work. But that means that it's going to be difficult to control, like human. So we don't really know what other humans think, and then we are not going to know what other machines think. And more scholars are thinking about this problem, and there are a lot of scholarship regarding it. I recently found this piece quite interesting, gradual disempowerment. They are looking at less credible threats compared to other types of existential risks like human extinction scenarios. In the AI summit related conference, and Yoshua Bengio spoke about how he conceptualizes the human extinction scenario, and he put like 3 stages of extinction. And the first stage, the machines are gonna plan how he would take the world, and second stage, the machine is gonna manipulate people so that human will consolidate their efforts to build robotics and or other disciplines, and so that a machine will have full potential to exercise its power. And after a machine realizes that all of the related disciplines are developed very well, then they're no longer needing human, then they're going to take over the world. And so I found that scenario is very interesting because the interim level of human machine risks are related to this accumulative risk of manipulating human parts. And so maybe the psychological harm is not really just about psychological. Maybe it's just related to some kind of existential threats. And although it's not really like agreed upon among all the scholars, and some of scholar thinks that these risks are overrated. But anyway, I think that although maybe human wouldn't really go away, and machines never gonna have the power over human, but still these types of manipulation is really concerning because we are losing our agency without our full knowledge about it. And just to clarify the definition that I'm using is that I'm not really thinking about like some external adversarial actors. There are seats here. External adversarial actors like use machines to manipulate other people, but I'm thinking more about machines themselves manipulate people. So there are many interesting empirical studies out there, and I initially put together a lot of empirical studies related to it because legal scholars I've talked with, they didn't really believe AIs have this potential. But it became clearer while I'm talking to my lab members and other people in the conferences that here, at least at CITP, people know that there is existing potential of AI manipulation. So I'm gonna just briefly mention this recent study that is gonna be at iClear 2025, and this is the dark bench study conducted by European scholars. And they categorized dark patterns of AI systems, and what they call dark patterns are not really different from manipulation that I referred to. And so they are brand bias that, for example, Claude want to make anthropic, like in a more favorable way, and OpenAI will be endorsed by ChatGPT and something like that. And anthropomorphization is that you already know, and sneaking ideas and psychophancy and user retention, that AI being clingy about being together with users and or harmful generation. And so they gave some examples of AI being a little manipulative and not really innocuous to the AI human interactions. So they evaluated different models, and it appeared that this dark bench measured a lot of kinds of different manipulative strategies of models. And so if you're interested in more empirical evidence, and feel free to scan it and there is an initial presentation that I put together, and there are a bunch of other empirical evidence of it. Sorry, you wanted to take the picture. And so I'm going to talk about legal mitigations more. And so there is, yeah, go ahead.
Yeah, just as a question, like, what do you mean by manipulation here? Like, I know this is like a tricky question, but like, where would you frame manipulation? Like, where does persuasion and the manipulation begin?
Yeah, that's a great question. So I found that in the persuasion literature, and so there is a recent paper from Google DeepMind that in the persuasion literature, they classify acceptable influence as persuasion and unacceptable influence as manipulation. And they just classify through different methodologies or strategies that AI utilize. And so if it is closer to maybe gaslighting, then it becomes manipulation. But if it's just about promoting some ideas, but they classify it to persuasion, not manipulation. But I'm not very convinced by that framing, and so it's just looking at methodologies. I'm not really sure about its comprehensiveness as a framework, but I think it's a good starting point. And currently, I don't have a very good definition of manipulation, but my current focus is that its outcome is the alteration of human thoughts, and also there are some systemic and opaque way of influencing those thoughts. And so it could be very easy to detect through methodology, but sometimes it could be difficult to detect, and maybe you need to look at very long chains of conversations in the long term. And so, yeah, I'm currently thinking of how we can empirically define this manipulation. And so it's still going on, but I'm currently looking at its outcome as alteration of human thoughts. Yeah. Um, and so for legal mitigations, and you might already know that the US is not a big fan of regulatory system. The legal scholars call it adversarial system because it doesn't really assume the administrative agencies make rules or enforce rules, but it's more about courts-based and adversarial parties like debate, and they find rules through this conflicts and dispute resolution system. But in the EU and Asia, regulatory systems more common. In that case, there are some expert administrative agencies there, and they make rule. Of course, Congress make the bigger rule, but agencies interpret rule or interpreting rules. Then sometimes they enforce rules with varying degrees of power, and companies should follow those agency-made rules. So this is a very big difference between adversarial system and regulatory system. And as I mentioned, adversarial systems don't really work, this type of psychological and unintentional harms, but there are very few cases when liability system worked. And for example, this is a speed filter case on Snapchat. So on Snapchat, there was a speed filter, and if you take the photo and the filter shows that how fast you are now, and then that encouraged teenagers to speed on their car, and it became very big accidents, and some people died, and some people became paralyzed and disabled, and so it just became too many. And then Ninth Circuit denied the application of Section 230 immunity of Snapchat because a speed filter was a defective product, and then Section 230 liability immunity wouldn't really apply. And so there are some legal technicalities here, but sometimes it works, but only in very big outcomes. So some people should have died. So why do we need to really wait for this type of big consequences like arise, especially if this type of manipulative potential could arise like systematically in a bigger scale? So EU AI Act has some components of manipulative techniques. And they recently released the guideline of interpreting this rule, and they a little disappointing to me that they really narrowed down the reading of this rule. So if you read this rule, it's like it's still pretty narrow. Like it should be purposefully manipulative or deceptive techniques. So it means that you need to prove the AI developers were purposeful to make the model manipulative or deceptive, and so it doesn't really include the broader definition of manipulation. And in the guideline, they really try to narrow it down to more like subliminal techniques, like secretly injecting some images or words into the model to an unknown way. Anyway, but EU AI Act is trying to address this manipulative problem. So I was thinking of, can we make similar types of regulation, like prohibiting the manipulative practices within conversational AI systems, like very, very simple stuff, or mandatory displays of toxicity level of conversations. So the second part is more like self-regulatory, and the first part is more prohibitive and regulatory. And of course, AI service providers wouldn't be really happy about it because it's difficult to implement, and also they might think that these types of regulation would violate their own free speech rights. And maybe surprising to some of you, or not really surprising to some of you, and First Amendment case law might give quite good justification for this AI service providers arguments. So like this type of regulation against AI's manipulative potential violate the free speech rights of AI service provider. So that struck me, at least, because the First Amendment wasn't, as I believe, First Amendment wasn't intended to really protect corporates' free speech rights, but it just developed that way. And the first, what is the reason behind it? There are multiple, and maybe like single case didn't really intend to make this way, but corporate lawyers are smart enough to use all those elements of development of case law in favor of the corporation. So the first, expansion of speech. So there is a Spence criteria, and so if you want to constitute speech, just two elements would be good enough. And first is communicative intent of speaker, and second is messages that can be understood by reasonable observers. So it sounds like quite speech, but then does it include programming language, or does it include AI architecture? Does it include AI outputs? So there is no clear answer yet. But recently, the Supreme Court didn't really deny. So it doesn't mean that it says yes to it, but it didn't really deny the extension of speech to content moderation algorithms or content moderation results of social media companies. So there are like 70 versus 30, so 70% of legal scholars think that content moderation algorithm would constitute some forms of speech, and maybe 30% don't really think that way. So there is a debate around it. But I feel that, do we really think too much about what is speech and what is not? And is it really fair to attribute to like everything to the definition of speech? And the other thing is that very clear categorical distinction between public actors and private actors. And so regarding the US Constitution Bills of Rights, public is the adversary. So it's like protecting individuals against, or protecting private actors against state actors. So there is only one exception, 13th Amendment, but other than that, everything is about regulating public actors against their like sensorial motive or other types of motive of right infringing state actions. So private actors are considered victims and state actors considered as adversaries. And there is no distinction between individuals and institutions, at least in the First Amendment. There was, but it is disappearing. And also there is a compelled speech doctrine. It wasn't really significant maybe 30 years ago, but now compelled speech doctrine, Mihir knows really well, and I think he wrote amicus brief about it. A compelled speech doctrine as the main vehicle of deregulation, because like corporations have faced a lot of different disclosure requirements, such as nutrition labeling, or just any types of disclosure, like tax reports or filing under the SEC regulations, but they started to label it as compelled speech. Like, we didn't really want to speak, but the government told me to disclose these types of information, then that's compelled speech, so that infringes on our free speech rights. And some courts made some concerning decisions, like if the information is controversial, if it is about opinion, if it is not about factual observations, then those types of disclosure requirements would constitute compelled speech, and then it will face heightened scrutiny under the court. So all of these four elements just come together, and so speech expands, and private actors always on the victim side, and there is no distinction between individuals and institutions. So although institutions have a lot of power, and sometimes it shapes and conditions and controls like individuals' speech forms in a very significant way, but still that institutions are just subject to the protection of First Amendment, not being regulated by First Amendment. So this is more theoretical thing, maybe not too interesting to you. So it's a historical overlook of First Amendment. So when First Amendment first started in 1920, so it's a little recent than other legal rights. Back then, the courts called it like expressive freedom of little people. So it's more about individuals like picketing on the street, and they are distributing the pamphlets on the street. And so it's more about like the marginalized people really need their forums to speak, and then their rights shouldn't be oppressed by the majority view. So it's more about religious minority or labor's rights. And so back then it's more about giving a forum to little people. But during the 1940 to 1990, the mass media era started, and then there were some debates between whether the listeners or the public have access to rights to more information through mass media, or mass media themselves have editorial discretion. So this type of individuals versus institutions kind of have started, and in some cases courts thought that the public has right to receive information, so the mass media's rights should be controlled a little bit, but sometimes they thought mass media should have broader editorial discretion and shouldn't be conditioned by the concerns about the public. And then it became more formal and formal equality, and formal equalities means that if it constitutes speech, if it satisfies the elements of speech, then the same level of protection will be provided. I think this Justice Scalia's comments well captures this type of formal equality interpretation of speech. So it is read as the First Amendment is written in terms of speech, not speakers. Its text offers no foothold for excluding any category of speaker, from single individuals to partnerships of individuals to unincorporated or corporations. So we are therefore simply left with the question whether the speech at issue in this case is speech covered by the First Amendment. So it means that even corporate speech is still speech, especially corporate non-commercial speech, like campaign contribution in this case. It is considered just political speech as like individuals' political speech. So then it faces heightened scrutiny. So this is concerning to many people. And so there are some voices from legal scholars about the First Amendment does not protect replicants, written by famous Lawrence Lessig. And He thinks that, and I think Amy Barrett, the Justice Amy Barrett, also authored like similar opinions in Moody in her concurring decision. The algorithms or any types of programming languages outputs are attenuated by the initial creator. So programmers are not really speakers because they don't really know what they're going to talk about, what the machine is going to talk about. So these type of human replicants are not really protected. Or a speech certainty article recently, and that's about kind of a similar thing. The programmers don't really know, especially complex machine learning system. They don't really know what they're gonna talk about, and so it means that there is no speech certainty, maybe no communicative intent. Then it's not about speech. But I'm not really sure about really just focusing on the definition of speech, because I feel like some parts of programming language constitutes speech and some parts are not. But still, even if it's considered speech, there should be some ways of regulating it, and why it constitutes speech and then it automatically just gets full protection of First Amendment and nobody can regulate it. It just doesn't really make sense to me. And I just followed all the footprints of freedom of thought, because everybody who works on freedom of thought kind of declares that freedom of thought has been dead for so long. And so I wondered, is it really dead? And so it doesn't have any traces in the First Amendment law. And so I followed almost every case that has the the words, the phrases of freedom of thought. And quite surprisingly, there are a bunch of cases. And although it's true that not many cases were just ruled based on only freedom of thought, but courts like to refer to freedom of thought, especially when it comes to the right to receive information related to listeners' rights, so called. And while doing so, and it emerged that quite clear power dynamics exist, not only social media or AI companies, but historically, there are powerful institutions that condition or spread information over the public, or make the rule over speech forums. And these institutions always kind of partially spread their own views and partially host others' views. And courts sometimes take the side of the public, or they justify the regulation over these institutions for the sake of the public, or sometimes they uphold the rights of these institutions for the sake of public. And so these institutions include advertisers and libraries and schools and media and churches. And state can regulate or support these institutions. And different institutions have faced different types of legal challenges. And for example, churches, state cannot regulate churches, of course, but state also cannot fund churches because of the freedom of religion and establishment clause, and also as a part of First Amendment. And state can fund media, especially it has public nature, but it cannot almost never regulate the content of media, because media's main function is expressive function, but it has a spectrum. Some media's sole purpose is spreading their own view, but some media is more about hosting other speech. And if it hosts other speech, and state may be able to regulate their role. And so there is a spectrum about it. And schools and libraries, and they are subject to many different types of regulation of the state, but still there is some conflict between these institutions and state, because schools want to have academic freedom, and libraries also want to have their professional responsibility of librarians and to maintain their collection. And whenever state kind of imposes certain types of views over these libraries or schools, then they resist, and then they create some norms. And sometimes libraries win, and sometimes schools win, sometimes they don't.
And for advertisers, and I haven't seen any cases that state like funded advertisers because they are really, really private. But states want to regulate advertisers because it could create harms like misleading customers or deceive customers, and so state historically has more power over regulating advertisers as commercial speech. So in all those cases, there are public behind it. Sometimes courts explicitly acknowledge it, sometimes not, but still I could find there are many footprints of the existence of the public in this, in the considerations of the courts. And I found some philosophical and justification for the different treatments between individuals and institutions from Louis Althusser from France. He calls it ideological state apparatus. And this exactly mentions all these types of institutions like public education, media, churches, maybe not libraries, but he mentions culture institutions and corporations. So his idea is that the government, court, and Congress, and they constitute repressive state apparatus, like kind of concrete way of defining states based on their exclusive power over violence. But ideological state apparatus, they are not really public, but still they are reflecting the majority view. They're reinforcing the interest of ruling class because Althusser has some Marxism ideology. So he was quite skeptical about these institutions influencing our own thoughts. And so he thought that the public should have some ways of controlling this IAS. So if we can I feel that this is quite common sense, like institutions have different power over overall like public opinions and general speech compared to individuals. And also the original focus of First Amendment has been on individuals, not corporations. And so I think that current singular notion of speaker is misleading, and speakers should have different levels, and especially between institutions and individuals. And the current framing of right to speak and should be diversified toward right to read, think, and speak. And the current focus on formal equality should be abandoned, I would say. And if there are collective interests of the public, and it should precede the institution's speech rights. Also, I want to note that this is the way of realizing the democratic will of the public. Probably very few ways of the public to claim their roles and their power over this ideological state apparatus. So then if we go back to the very sketchy AI regulation that I drafted about prohibiting the manipulative practices of AI systems and mandatory disclosure of toxicity of conversations, this human-centered First Amendment framework give you very rough ideas about evaluating those regulations. So the important thing to note is that First Amendment has never been the vehicle of crafting very concrete regulation. It's just about contouring the boundaries of regulation. So with that in mind, I think that the freedom of thought provides good justification for regulating institutional power over individual speech rights. Individuals' right to think, even though there is no expressed thought yet, but still its potential power over formulating individual thoughts could be a good reason for why we should make it as a subject of regulation. And the government regulation with censorial motive is deemed as the violation of the listener's rights. And so even though the institution cannot really enjoy the same level of free speech protection, but still there is the listener's rights to receive information. And so if the government tries to regulate AI systems to promote their own views, like I don't know, like Communist Party's views, and in some countries, then it should violate the public's First Amendment right. And mandatory documentation will not constitute compelled speech, and rather it should be considered as permissible regulations for empowering individual choices. So that's pretty much it, and I'm gonna conclude my presentation with this, and happy to answer any questions. Thank you.
Do you say that speech like that is factual, like as might not necessarily be compelled speech, like, or do you think, or if we were to do some toxicity labels, that could you make an argument that that is just a factual, like a metric of toxicity?
Yeah, I think factual versus non-factual. Yeah, so currently I don't think it has been upheld in the Supreme Court, but some lower courts have thought that factual compelled speech is not subject to it is subject to intermediate scrutiny, but non-factual disclosure is subject to like heightened or even strict scrutiny. I think Bonta versus Net Choice ruled that way, but I think that's the mistaken reading of the Supreme Court cases, and it never said that non-factual disclosure should be subject to strict scrutiny. It said that factual information should be subject to much lower scrutiny. So I think even though it's controversial, it contains some opinions, as long as it clearly not really forcing opinions, like if there, for example, there is hygiene like standards in Washington State. And so there is a rule of very good hygiene to excellent hygiene level, and needs to improve hygiene level. And so there is a rule and there is assessment. Maybe the restaurants don't really agree with the assessment, but still it has the opportunity to contest those assessments, and then it's controversial. I think it's not purely factual whether it needs to improve or it's good or excellent, but still I don't think that kind of disclosure would be subject to like heightened or strict scrutiny. So I feel that like factual and non-factual distinction is not really fair. And although it's not factual, if the institution has enough opportunity to disagree with it and contest it, but still it has to follow it. And so everybody knows that the restaurants wouldn't really agree with the result. It's not about they really agree, wholeheartedly agree, and they really express their views that way, but it's just like complying with all the regulations. And so I feel that it's very different from the individual's oath. So compelled speech developed from the oath cases. So it's about, I really believe in the Constitution of the US law. So the US Constitution, that's kind of fair, but sometimes some states force someone to make an oath about religious belief. So I believe in God. So that's really different from like complying with the disclosure regulation. So yeah, although it's controversial, I think that it should be permissible. It's a very long explanation.
So I guess I was wondering, under your rule, let me give you like an instance of Meta doing content moderation and ask you under your rule how you decide, right? So the accusation was that the Biden administration was communicating with Meta about the removal of content that had to do with COVID-19. Meta was communicating back with the Biden administration about this and et cetera. And what they were trying to do, one way to look at it is, they were trying to create an information environment around COVID-19, which actually allowed their users to make their own decisions with respect to COVID-19, even by removing factual information. So they were removing facts, but they were trying to create a clean decision environment for their users. Would they, under your rule, be forbidden from doing that because they were removing factual information?
Oh, so is the state is forbidden or Meta is forbidden?
Meta, in this case, let's say.
Oh. Yeah, I've only thought about using First Amendment as, so I haven't thought about using this framework directly addressing the corporations or institutions, and so I was more thinking about in that case the state was accused of infringing it's like coercing like Meta to remove those content, and so I was more thinking about whether the state's acts were permissible or forbidden, and I haven't thought about the institutions should be forbidden to remove certain content. I think that's
It seems like you were
under.
wanting to say that any kind of algorithmic moderation that they do is in fact their speech. But that's okay because simply because it's speech doesn't mean that it has to be left untouched, right? So just kind of trying to point at that edge case, like what would you say with that? Should that type of speech be touched by the state? Should they be forbidden from doing that, or actually encouraged to do that in order to create a human-centered information environment?
I think in principle, it falls under the editorial discretion of the Meta, but given the circumstance, the COVID-19 and the public health crisis, and the public has the right to receive fair information given those urgent matter. So, and also I think in that case, there were like factual debates about whether state like literally coerced it or just recommended it. But anyway, I feel that the editorial discretion of Meta can be limited in that cases, and so Meta is not forbidden to do so, and also the state is not forbidden to recommend the removal of content. So that's why. So none of these parties are forbidden. Yeah.
Can you talk about what kinds of transparency disclosures receive heightened scrutiny under First Amendment? So you talked about facts, and then I think you also mentioned opinions during your talk, but is there like a broader framework that we should know about, or
I think that's the only framework, fact versus opinion. How do you think we here?
Yeah, sure.
Yeah. But the level, like the exact level of scrutiny hasn't really been decided. And the recent Netchoice versus Bonta case, and it's about the disclosure of harmful content, harmful to children. Then in that case, the courts applied like strict scrutiny, the most heightened version of scrutiny, and that's currently under the debate, and not many people really agree with it. But anyway, the fact versus non-fact is.
Is the format in which the information is presented like a factor in this decision?
Think so. Yeah, I think so. And it should be, because it follows at least the doctrine of compelled speech, and so whether they were compelled, and so some courts uses the phrase of putting words into mouth, and so if it literally like putting some words into mouth, then it sounds more compelled. But if it is more about displaying some third party's assessments, then it doesn't really sound like their own opinion, then probably it feels less compelled. So the format will, I think, matter.
Anyone on Zoom?
I guess to go back to your first point about manipulation and pointing that out, is it possible for the government to say, I know that for IoT devices or such, you could have some sort of labeling regime.
IoT, Internet of
Yeah,
Things.
in Internet of Things, about how I think NIST somewhat recently was talking about how they were coming up with a voluntary labeling regime of the security standards inside IoT devices. Do you think, just from a policy perspective, if we wanted to be able to say there's some way to point out manipulation, and perhaps we don't make companies label it themselves, but is there some third party? What are the policy levers that you see to specifically address this issue of manipulation within the United States?
Yeah, that's a good question. I think, yeah, I don't really have good methods of regulation other than the methods that are already currently incorporated in other regulations like labeling or auditing, or third-party assessments or documentation and disclosure of information or evaluation, and monitoring, like human-in-the-loop monitoring and verification. And so I feel that those are just categories of many different technical implementation of regulation, as well as, yeah, I've thought of other laws, involving other stakeholders to assess what's going on. And there is some movement of creating professional responsibility for AI engineers. And also, I know that some OpenAI employees kind of made some open letter to create some internal protection system for whistleblowers if there is safety concerns. And so those I'm not sure about licensing AI engineers like doctors or lawyers, but I can see why those initiatives arise, and that kind of makes sense to me. And so if there is a way between licensing versus non-licensing, I think it could be an interesting way of addressing those threats in an earlier stage. And also, I'm thinking of maybe we can create, I think it was suggested by Ryan Kalo a long time ago regarding social media systems. Maybe we can create some sort of IRB system in the AI industry. So if there is a federal law that govern the entire review board, and each institution could create their own self-regulatory organization that's similar to universities' IRB, and those IRBs directly report to those federal regulatory agency, then it would have different priority other than the corporate for-profit motive. And so it might create some incentives of addressing those threats. So I'm thinking of involving stakeholders, but other than that, I'm kind of out of imagination.
Thank you.
This is maybe a bit, too out there, but I was thinking what are the rights-based underpinnings of protecting underage people from psychological harm? Because it seems like as a society, protecting adults from psychological harm doesn't seem to be our top priority, but in some ways we do care about children. And what do you have to, for example, prove? What is the right that's being protected when, parents can't emotionally abuse their children, whether or not it's intentional? Is there such a thing in the law?
Yeah, I think the laws, the legislation that regulating certain behavior to protect children have been upheld compared to other laws in the same field, like privacy law, And what I think Bonta case was related to protection of children, but still net choice won in those cases. So it's not really clear cut, but it has been if the justification for law is about children and the courts kind of respected the legislative discretion of creating those regulations, but it has been changing. But there is a clear history of protecting child has been a priority over compared to protecting adults. And there is a Online Safety Act in the UK, and it used to have content harmful to adults and content harmful to children, and then they removed content harmful to adults for that reason that you mentioned, because it's too paternalistic if the state kind of creates a rule over content harmful to adults, and so they just have harmful content to children now. And so, yeah, so because children is deemed more vulnerable compared to adults, and so kind of like it's a kind of flipping coins, and so children has limited freedom of thought, and children has limited right to information, right to receive information. So some sort of regulations to protect children, which means that limit the access of children to certain information has been justified.
Is there any consensus, like in the legal community, about whether companies like OpenAI would be considered providers? Like, what's the conversation on that right now?
Regarding
You just mentioned earlier, like, and like, I guess, excuse me, how like the arguments around like, are social media companies like newspaper stands, like that kind of thing, like that definition of provider? Do you have any insight?
I think they are positioning themselves as newspapers. Yeah, to I think so. At least Sam Altman said that Section 230 wouldn't really protect them because they are not really an intermediary of a third-party speech. They are kind of making their own speech, and so he doesn't think that Section 230 give full protection for ChatGPT's outputs. So, and yeah, why are you? I mean, so but for social media was able to convince courts that they are newspapers for the First Amendment perspective, but they are not speaker for the Section 230 perspective, and so they were able to find that sweet spot. But I have felt that yeah, go ahead.
I was gonna say, like, that may not be true going forward. I mean, there is a case making that point, working its way through the courts right now, that there's this inconsistency. So I think it's the TikTok v. Anderson case. But yeah, so there's that sort of point making its way through the courts right now. So we'll see if the Section 230 and First Amendment weird split will keep going.
Yeah, so for OpenAI, I feel that they have made kind of a little clearer than social media by making them as sort of speakers.
And there's also the character AI case that they just made this point in court, arguing that they're First Amendment protected speakers. So they just filed as expected.
But would you make the argument under your characteristics of speech thing, would you make the argument that that claim by OpenAI couldn't possibly be true because they just lack communicative intent? You did suggest that at one point during the talk, that they may program up a bot. The bot may then actually say things, but there's a wall there between their intent, whatever they did that was intentional, and the communicative act.
So I made very minority view here that so I dug into the nature of communicative intent and the nature of speech, and I don't really think that the the communicative intent or any types of definition of speech made a very satisfying satisfying delineation of protected speech. So my current conclusion is that even though it is speech, still it is regulable. So I don't really agree with that. Only all speech is not sort of unregulable. So even though I'm not fully convinced by like Lawrence Lastig's arguments that they are too attenuated by programmer's intent, and so we cannot really call it speech. But I feel that some forms of it could constitute forms of speech, but it doesn't necessarily deserve First Amendment protection. Yeah, so that's my current thinking, but maybe there could be a fascinating way of making the good definition of speech, and we can make the very clear line between protection and on-protection based on the definition of speech. But I'm getting more and more skeptical about just having the definition of speech at the center of every argument, especially we have institutions and corporations as speakers, and so that may work for other countries like Europe and Asia. They do not extend the same level of protection to corporations or institutions. So there is a critique about it, because in some cases, nonprofits should have same level of speech protection like individuals. So in those countries, and they kind of criticize that institutions should have more proactive speech rights. But in the US, and institutions have enjoyed kind of the very heightened level of protection. And so that's why I think that the definition of speech doesn't really give us like satisfying or reasonable conclusion.
I think we're just about at time, so let's thank Inyoung for this